Hello again, everybody. I'm Gene Valicenti in the NBC 10 newsroom. This is our daily recap of the retrial court action in the Karen Read case. Joining me is NBC 10's Katie Benoit, who's been up there. Also, one of our legal consultants, Peter Ellikin, an attorney in Boston. Let's begin with Karen Read, just outside court. She got the disappointing news that the U.S. Supreme Court will not take up her case for this to be ended. Let's listen to that.
Reaction to the Supreme Court not taking up the case?
No, fight on. Nothing's breaking me, Matt.
And your reaction to the expert with the Commonwealth saying that it wasn't 2:27, it was actually after 6 a.m.
Celebrate says 2:27, and it was deleted. Celebrate.
What do you think about that battery temperature battery?
Insightful. You'll hear more.
Stay tuned.
Stay tuned. Sorry.
Did you make calls to John's phone just like 90 seconds after you dropped him off?
No. 90 seconds, no.
2 minutes? I mean, it seemed pretty quick.
You'll get me in a minute.
All right, a little tough to hear what she's saying there, but essentially she said the fight goes on. Disappointing news. Let me bring Peter Ellikin, one of our attorneys who's following this forward. Peter, just most of us know you can't be tried twice for the same crime, double jeopardy, unless what? Fill in the blank. How come it didn't work for her? She went all the way up to the U.S. Supreme Court. Why?
This was very unusual. What happened is, as we said, the number of jurors who come forward said they did find her not guilty of 2 of the counts. Mm-hmm. However, it was almost inexplicable that they never told the judge that, didn't announce it, didn't hand in jury slips, and therefore the courts have said it didn't count. They said their version was that we didn't know it was all or nothing. Since we were deadlocked on 1 of the 3 counts and 2 of them we thought she was not guilty, we just thought it was we'd have to just say deadlocked on everything. So that was where the confusion was. Yep. And so we really do have a unique situation where she very well may have been found not guilty on 2 of the counts. And as the first person in Massachusetts history, I think, to then be retried. However, the law is pretty clear that you need to announce it in open court, hand in jury slips, etc. So it was not a surprise that the Supreme Court did turn this down. And that's the end of the game, really. That's the final word.
Yeah. Was it judicial error from what you've just outlined there? And there was nowhere else for her to go? She went all the way to the U.S. Supreme Court. They just wouldn't hear it. Go ahead.
Right. No, I wouldn't say it was judicial error. The judge followed the way the law is written now, that when you find somebody not guilty, it's you got to tell it in open court. And she was backed up by, they appealed it to the state appeals court and the state Supreme Judicial Court and the federal courts and the U.S. Supreme Court. And everybody has backed up the judge. So I guess that's the way the law is, but it's still something of an unfair situation, but completely legal what happened.
All right. Well, not judicial error, but just peculiar to that particular law that they were applying. NBC 10's Katie Benoit's been up there. Katie, there was testimony today. Again, the jury's back in court, having had the view last week. They went out to the scene of the crime. There were some accident reconstruction people who were brought in, and then the jury did not hear that. What was the point of that? Why are these experts, accident reconstruction people, brought in, but outside the jury's listening to it? Why?
Mm-hmm. So basically, there's been some issues. There's some things the Commonwealth still wants to figure out. Now, the first trial, these ARCA witnesses, they were hired by the federal government and they testified for the defense, but the defense, painted them as independent experts in the trial. So there were some questions about communications between the ARCA experts and the defense, how close their relationship was in the first trial. And turns out there was a bill that ended up being sent to the defense after the first trial was done. So the Commonwealth wanted these witnesses, these expert witnesses, to come in today and talk about their relationship with the defense. Hank Brennan really questioned the experts. Things get heated a little bit during court, but basically without the jury, they can kind of solve some problems, hear some testimony, things they wouldn't want the jury to hear just yet.
All right. ARCA means accident reconstruction. Peter, should I pay attention to what happened outside of the jury's listening today, or should I just ignore it if you're trying to follow this case? Is that central to anything here, or they came in, it was more procedural stuff for the judge?
Yes, it really was. This was kind of everything about this case is very unusual. Every time we talk about this case, we go, gee, I never saw this one before. But these experts, reconstruction experts, were hired by the feds, and independent investigation had nothing to do with the defense or prosecution here. And what they said is that the Karen Reed's, O'Keefe's injuries were not consistent with being hit by a car. So when they finally got permission to kind of testify at the state trial, and they didn't change their testimony, whatever they had said to the feds, stayed with it. But the judge was concerned because the defense did talk to them about a lot of things before the trial and didn't let the court know, because you're supposed to, certainly defense or prosecution could have talked to these people beforehand, these experts, before they testified. But you're supposed to let the judge and the court know that, yes, we had conversations. And ultimately, after the trial was over, ARCA sent a bill to the defense, which the defense paid. They said they didn't know about it beforehand. But the judge when she found out about this, was very upset that nobody knew about this relationship, even though it was fine what the ARCA people would have testified on.
Yeah. Well, for our purposes, just a layman watching at home, that really gets in the weeds. But this we could all understand. This is the infamous text, or rather the infamous Google search done by someone inside that home. How long does it take a body to die? That we all get. Katie, set that up for us. Who did the Google search? Who do we suspect did the Google search?
Mm-hmm. So Jennifer McCabe, when she testified the last time around, claims that Karen Reed asked her at the scene. Jen McCabe was with Karen when they found John O'Keefe outside, and she claims that Karen asked her to do this search. Now, when the experts were looking at the cell phone data, there was a timestamp that said 2:27. So there was some confusion about what time this search actually happened. Did it happen before John O'Keefe was found or after John O'Keefe was found? So this has kind of been a controversial thing that's gone back and forth. The defense has their own witness who will come in and testify. But today we heard from a Celebrate expert, the Commonwealth's expert, and he came in and said that search didn't happen at 2:27. It happened later on after John O'Keefe's body was found.
All right, let's hear from this expert. He's a computer forensics person. He can go in and find anything he wants to on your computer, provided you haven't bleached it or bleached to bit it. Let's listen to this guy talking about how he found this Google search. How long does it take a body to die? Play that.
It's 24:18. There's a second search submitted using the same method, so still using the Safari search bar. This time searching for Hoss Long to die in cold.
And there's actually a second bite with Ian. Play that as well. He was one of the witnesses today. Again, a computer forensics guy who went in and found this Google search.
24:33. How close is the phone to that flagpole?
I believe very close.
And do you ever see the car or the phone stop anywhere near that driveway?
No.
All right, Peter, back to you for just a second. Is there anything, this Google search, how long does it take a body to die in the snow? Obviously, it sounds like it's incriminating somebody, but is there any way that this could be looked at a different way? That, well, if somebody is panicking and concerned and really wants to know how long was he out there, is there any way that the defense can spin this?
Well, not that way. Let me explain. The key is what time it was made, because if, as the defense said, the timestamp said 2:27 a.m.,
right,
that would be like, if we could confirm that, that would be proof positive, I guess, that they knew that he was lying out there hours and hours before he was discovered.
Okay.
Now, this is where we get into the battle of the experts. I hate to use that cliched phrase, but prosecution is saying, no, the timestamp is wrong. And they all kinds of technical reasons why they actually did it, because they were panicked. And after they found the body in the snow, at some point, somebody was curious at 6. So that's at 6 after 6 a.m. Okay. So that is the key issue that the experts are going to battle on. Was that statement made at 2:27 a.m., which would be really nail the case and be good for the defense, or was it made after 6 o'clock? So therefore, it's not at 6 a.m. and therefore it doesn't mean anything. It was just a concerned person.
I follow the significance of the timing more so than the significance of the body of the Google search. Just talk about the body of the Google search, though. That's most people can understand now. Why would somebody, are they searching it for nefarious reasons, or searching it just because they're concerned? There's a body found outside. How long does it take?
Well, right. And but it would be very coincidental that if the defense's whole thing is that he was beaten up and they took his body and let it lay out in the snow there. Yep. And if it could be determined that was made at 2:27 in the morning, that somebody, inside the house perhaps was Googling that And
Yep.
I'm curious how long it was going to take him to die out there. That would be strong evidence that he was beaten up in the house and they laid him out there. Why else would, would anybody be curious out of that? It's just too coincidental. However, as we say, the prosecution says no. It makes a lot of sense that somebody asked it after he'd been lying out there and his body was discovered after 6 o'clock in the morning.
When this comes up in open court with the jury listening, are they framing it? Are they serving it up so that the jury is getting the significance of the timing, or are they just making their arguments and hoping the jury puts 2 and 2 together?
No, they are. Each side is going to argue that very strongly, and they're going to argue that probably even at the end of the trial in the closing arguments, they're each going to argue their this thing on the timeline, which is so crucial. So yeah, I think they are going to. They're going to really serve that up to the jury in a silver platter and really point out the significance about why would you, be curious about how long it takes a body to die in the snow, unless you just put the body out there in the snow. So the jury will definitely get be told why that's relevant.
All right. And Katie, just one more time, the person who was actually doing the Google search, are both sides disagreeing on who did the search, or was this pretty much agreement on the person who did the search?
There's agreement on who did the search, but again, we'll hear it down the line from the defense expert who will say something different. At least last time around, he said something different than the Commonwealth's expert. So kind of like Peter was saying, these battling experts we'll expect to hear from on both sides throughout the trial.
Right. Well, listen, we're all just going over this, and you two are really plugged in, but you could see how just the average person at home maybe saying, what is that again? What is that again? You think that's a problem for the jury too? You really have to be tuned in, and at some point you lose their attention, Peter.
I don't know. Actually, this all, I think, goes to the benefit of the defense, because if the jury, if they're hearing both sides and they hear two experts, let's say, argue with each other, and the jury winds up scratching their head and say, I don't know, I heard two stories, I don't know who to believe, then that goes to the idea of, was the case proven beyond a reasonable doubt? It's like the old baseball phrase, tie goes to the runner. And if the jury at the end of this trial says, gee, we heard two stories, we don't really know, we're not really sure, at that point, then you have to acquit. You'd say it wasn't proven beyond a reasonable doubt.
Well, they certainly are laying that foundation. Peter, thanks. We'll join you again. Appreciate your time. Katie Benoit, you keep covering for us. And folks, keep watching our daily debrief on all the court action in the Karen retrial. We do it every day after 5 o'clock when court is over. I'm Gene Valicenti for now. We'll see you on the news at 6.